Law Weekly, we assess the judiciary in the outgoing year. We also talk about the debate in some quarters on whether the prosecution of recently released former governor of Delta State, Chief James Ibori, would amount to double jeopardy. Our guest is Senior Advocate of Nigeria, Femi Falana. That's the lineup. Hello and welcome. I am Shola Shuyeli. Last week on the program, a former president of the Nigerian Bar Association, Chief Wole Olanipekun SAN, gave us his assessment of the judiciary. He also spoke about the status of the acting Chief Justice of Nigeria and called on the president to immediately send his name to the Senate for confirmation. Today on the program, we get another perspective. Mr. Femi Falana is a well-known human rights activist who was called to the bar in 1982 and conferred with the rank of SAN in 2012. He's often at the forefront of campaigns against corruption and championing the rights of the poor, the disadvantaged, and the masses, and he's won numerous awards locally and internationally for his activism. In this interview, I began by asking his opinion on how the judiciary fared in the year 2016.
I think it's been a challenging year for the judiciary, in spite of the embarrassment arising from the arrest of some judges. I think within the ambit of the Constitution, the judiciary tried as much as possible to promote the rule of law. Majority of the election petition cases, or the appeals arising from election petition cases that were not disposed of last year, were heard and concluded this year, even though, curiously, some are still, pending in court. A number of our courts were able to operate under the, engage in the religious implementation of the Administration of Criminal Justice Act 2015, and I'm talking of the federal courts, the Federal High Court in particular. So that at the end of the day, if you take the EFCC, for instance, in the last 1 year, in 2016, the EFCC has been able to conclude and ensure the conviction of not less than 200 people, including politically exposed persons. So I think, or if you also take the National Industrial Court, many labor-related matters, employment cases were speedily tried and concluded. So we're getting to, we can say with confidence that the judiciary performed creditably well for the ruling class. For the ordinary people, the masses of our people, who have problems having contact with the law, we have a lot of room for improvement. Congestion of cases remains, congestion of our courts because of numerous cases still remains a major problem. And so you have majority of prison inmates who are awaiting trial, whose cases were not heard, undetermined, and those who have no access to lawyers or senior lawyers complain of injustice arising from delay in the hearing of their cases. So, on the average, I would think the judiciary performed creditably well, in the interest of the ruling class or the system, the neo-colonial system. But in terms of getting redress or extending justice to the poor and disadvantaged segments of our society, there is a lot of challenge.
So what do you think that we can do better as regards those issues in the new year?
I think our courts, our judges have to adopt case management and embark on alternative dispute resolution in resolving many cases that are pending in courts. We will need to appoint more judges to man many of our courts, we need to improve on the working conditions of our judges. I mean, because for me, it's unacceptable, it's intolerable for our judges to continue to write longhand, you know, to take evidence, you know. We also need to equip our courts. Many of the courts have there's no electricity supply. I mean, the state courts are worse. The federal government has taken the issue of financial autonomy for the judiciary much more seriously than the states. And I can tell you, little or no attention is paid to customary courts and magistrate courts and area courts, where you find the majority of our population seeking justice. And I have also found, you know, that many cases are determined by our traditional institution. And we haven't paid any attention to that area of our administration of justice in the country. So, for the appellate courts, I'm disturbed that our courts have not seriously addressed the disturbing volume of work. And I can tell you that our Supreme Court is the busiest in the world. Even though many Supreme Court justices, courts, like the acting Chief Justice recently said, the Honorable Justice Walter Onogen, that we're okay with 17 justices of the court. In many jurisdictions, like the US or India, they have only 9 justices in their Supreme Court. Yet, they are able to decide at the beginning of the year how many cases are going to be handled. But here, it's problematic because we allow cases to move from the customary or Sharia courts or area courts and customary, magistrate court up to the Supreme Court. And you can appeal on any issue. So you have the appeal courts congested unnecessarily. And I would also think that the judiciary has not addressed how to reduce the number of cases that go to our court. For instance, and this has been my position, since the practice in the Court of Appeal and the Supreme Court is the same, why do you ask a lawyer or lawyers who want to become senior advocates to have a certain number of cases in the Supreme Court, in the Court of Appeal, and the High Courts? It should be either the Court of Appeal or the Supreme Court. You now have a situation whereby lawyers go to the prisons to instigate appeals. Others pay members of the public, litigants, to have their cases taken up, filed in the Supreme Court and prosecuted there. So, for me, this is a matter that we can simply resolve by saying, if you have, because this is not possible, it doesn't happen in other parts of the world, that every lawyer goes to the Supreme Court, because only few cases go there to clear doubts in the law. But now, in the case of Nigeria, any appeal can go there.
How do you propose that the Supreme Court sift which cases go on appeal? Because I've heard some people say that perhaps you form another panel of the Supreme Court to determine which cases can go on appeal.
No, you do not need a special panel. Judges are supposed to have able assistants. In many parts of the world, you have professors of law assisting the Supreme Court. So you must look for academics to assist our judges so that they'll be able to sift, they'll be able to find out whether you are raising any new point, So it's not going to be based on whether the other side is opposing the application or not. We must have people can assist our judges to, organize the courts. And the other one I find disturbing. I remember in 2011 when the National Assembly was proposing the amendment of the Constitution, and I learned that the Supreme Court was going to hear appeals arising from governorship elections. I had to rush to Abuja to try to persuade the National Assembly that you are going to create more problems for the Supreme Court. Surprisingly, I was told that the Supreme Court wanted it. Surprisingly, the president of the bar at that time came to make a case for it. And at the end of the day, we have pre-election matters, election petition cases coming from the 36 states being decided by the Supreme Court. It shouldn't be so. The other one that will help our cause, we're only lucky that people are not yet demanding for their rights. Why should my case be suspended for 6 months by the Lagos High Court? Because the judge handling my case has been posted to Sokoto or Zamfara or, Borno State to sit on an election petition matter. Why should that be so? I'm talking of what happens in election years, where we assemble 400 to 500 judges all over the country and post them to different states. I mean, it shouldn't be so. Again, up to the Second Republic, election petitions arising from states were decided in those states by the judges. In fact, the chief judges will constitute the tribunals, right? And head them. The chief judges headed the election petition tribunal in their states. Up to now, we have no problem with state high courts or even the federal high courts hearing pre-election matters. But when it comes to election petitions, post-election matters, we say, oh, no, this judges from these states are likely to be biased, so let's go to other areas. But that has promoted corruption. Because if you want to take money in your state, take it by all means and cause problem in your state. It's better than posting people to other areas where they have no affinity, where they are not bothered about the sensibility of the people. And so we have run into problems unnecessarily. So for me, I think we should take advantage of the ongoing amendment of the Constitution to return to the status quo ante bellum, so as to save ourselves a lot of the problems that, are troubling for the judiciary now.
Have you made recommendations to the National Assembly on these issues?
I'm trying to persuade the relevant authorities, because if you make your recommendation and those who are supposed to benefit, from decongesting our courts, have their own agenda, what do you expect?
Let's move on now to the issue of the status of the acting Chief Justice of Nigeria. Last week on the show, I had Chief Oliola Nipekun, Senior Advocate of Nigeria, and he believes that the president should immediately forward the name to the Senate. Are you worried that we have an acting Chief Justice of Nigeria?
I've followed arguments on this matter, and for me, I believe very strongly that we should refrain from seemingly politicizing the matter. It is not the first time we're having an acting Chief Justice of the Federation, even though in the past, we're not expecting an acting Chief Justice to act for more than a month or two before the name is forwarded to the National Assembly. Where I ever have to take cognizance of the fact that this is a regime, this administration is extremely slow. And I think the president has made the point that he is very slow but steady. We do hope that the authorities will ensure that this matter is resolved as soon as possible, because when you put people in an acting position, you run into problems. And that is what has happened with in the case of the acting chair of the Economic and Financial Crimes Commission, Mr. Ibrahim Magu, whereby the majority of the allegations contained in the report of the State Security Service arose after his appointment as an acting chairman, whether the FCDA got a house for him, or whether he traveled with somebody who was a member of a presidential commission, or traveled to Mecca and the rest of them, arose after the appointment. And there is no way you can have an acting chairman of the EFCC for 6 months or 1 year without stamping of very powerful toes in this country. So you must avoid that kind of situation with the judiciary.